We have Dr.JP Lok Sabha Party's National President, Elizabeth Seshadri from Lok Sabha Tamil Nadu, joining the Hangout session this evening to discuss and debate on Judicial Reforms Bill. Many of us, believers and followers of Dr.JP, heard from him many times over these years that a reformer must have infinite patience, and for those that work sincerely and selflessly, the patience pays off. So judicial reforms is a dry subject for many of us, even those that are active in politics. JP sir and Elizabeth Seshadri, thanks for joining out the Hangout session this evening. First of all, JP sir, could you let us know about the need of this judicial reforms bill, about the 121st constitutional amendment, the hard work of Lok Sabha and FDR behind this?
Thank you, Sharwani, Elizabeth and friends. This is an important issue for debate, though it's a dry subject, as Sharwani said. Because unless a democracy knows how to structure the separation of powers, how to ensure that there are checks and balances in the system, how to make sure that no authority, no individual is supreme, but everybody has appropriate authority and accountability. Unless those institutions are properly in place, we always have a problem. And again, as Sharwani said, a democratic reformer requires infinite patience. This is a good illustration. This document I hold in my hand was presented to the National Advisory Council, not even prepared, presented on actually 8th July 2005. That is more than 9 years ago. Actually, we prepared the document after months or years of research and study and taking careful position. I think a couple of years before that, at least, maybe 2-3 years before that. That means already this is about 10 or 11 year effort, this particular thing. And you can see the title, National Judicial Commission, Judicial Appointments and Oversight. That's the title of this document. Now, largely because of this effort, and following that, later in 2010, we constituted this committee with these three eminent jurists. You can see the names: Justice V.R. Krishnaiyer, Justice M.N. Venkatachalaya, the former Chief Justice, and Justice J.S. Verma, the late Justice J.S. Verma, again a former Chief Justice. The reason why we have chosen these three eminent jurists is, A, they are and they were easily, by common consent, the greatest jurists in the past generation in India. When they were alive, they were the greatest living jurists of this country, with unimpeachable integrity, judicial rectitude, and enormous fund of goodwill and wisdom in the country. Nobody can dispute that. We anticipated that if there is any change in the current way of appointment of judges, it will be open to judicial challenge, and there is a chance that the Supreme Court may give a judgment which is not really constitutionally sound. And therefore, unless men of great distinction, unfortunately, we could not find a woman of comparable stature with those credentials. Therefore, they were all men. Men of great stature and credibility, unless they have their imprimatur on any kind of judicial appointments mechanism, it will run into constitutional challenge. And that's why we have thought through it very carefully. And then we kept the then government and the then opposition, now the ruling dispensation, fully informed of this. I personally kept the Prime Minister himself and the then Law Minister and Mr. L.K. Advani and Mr. Arun Jaitley and others continuously informed of what was happening. And this committee of these two jurists, they came up with the idea of a National Judicial Commission in this current form. The only difference is they suggested a 5-member commission, of whom 3 would be the judges, the Chief Justice and the 2 senior most judges. 1 would be Prime Minister or his nominee. The 5th would be the Law Minister. 1 would be the 4th would be the Prime Minister. The committee would be chaired by the Vice President of India. Whereas now in the current bill, there will be 3 judges, the Supreme Court Chief Justice and 2 senior most judges, and the Law Minister, and 2 members from outside the government, eminent persons nominated by a committee of the Prime Minister, the opposition leader, and the Chief Justice of India. So a 6-member committee, of whom only 1 member will be the government. There's a minor change, but otherwise there's nothing that is really in a fundamental way a departure from what was suggested. In fact, there's an improvement today because despite our suggestions, these three eminent jurists did not include the role of the opposition at that time. And this time the government wisely said, let there be opposition's role. And therefore, in constituting this committee and nominating these two external members, independent members who were eminent persons, the opposition leader and the Chief Justice of India both are consulted. And therefore, this is a more wholesome arrangement. Now, the argument that this is an encroachment of judicial integrity or freedom is absolutely self-serving. In no democracy, in no functioning democracy, do judges appoint their successors. The Constitution never envisaged that. In fact, Article 124 clearly said that judges are appointed in consultation with the Chief Justice of India and such other judges as the President will choose to consult. In fact, in the Constituent Assembly, there was a debate whether to make it in concurrence with the Chief Justice of India. After a debate, the Constituent Assembly said, no, concurrence is not warranted, consultation is what's necessary and sufficient. And that has been the practice until the 1993 judgment in the judge's case. Incidentally, Justice J.S. Verma, one of the participants in this committee and the signatory, was the man who wrote that judgment. And Justice Venkatachalaya was the Chief Justice at that time. So the people who were parties to that judgment, transferring the appointment powers to the Collegium of the Supreme Court, in effect, they are the ones who understood the damage done, and therefore they are the ones who proposed the change. And we involved them deliberately for this reason, because there must be a broader consensus and deeper examination of the issues, not a knee-jerk response, not an anti-judicial response. We wanted a pro-judicial response, because the challenge is, how do you protect the integrity and independence of the judiciary while enhancing its credibility? If the judiciary loses its credibility, when the nation really needs the judiciary's intervention, we would have a serious problem. Because right now you look at Pakistan. In Pakistan, a duly elected government, a constitutionally elected government, is now sought to be removed by the street agitation led by our own Imran Khan, the former cricket star, who is now using his popularity and celebrity status to bring down a popularly elected government through street agitation. And this is the time that the Supreme Court should have actually intervened. The same Supreme Court in Pakistan last year actually dismissed the elected governments. Two prime ministers were seriously undermined by the Supreme Court. Whereas today, when the nation is in crisis, Supreme Court simply washed its hands off and then is leaving it to the street. That's a very dangerous thing. So whenever there is a real danger in a fractious country, in an evolving democracy, in a diverse nation, let us say a matter of reservations where there cannot be a unanimity in this country by nature, or a matter like Babri Masjid where you don't want a street fight to decide, or some other very contentious issue where by definition there cannot be a political solution. These are situations when we need the Supreme Court to come and bring some sanity and to bring their authority and their credibility and their judicial temperament to play. And if the Supreme Court's credibility is not intact because of their overreach in other matters, then the nation is in danger. Therefore, the Supreme Court must be restrained and disciplined in order to actually enhance its power, its credibility and its strength and its ability to intervene in moments of great national crisis. That's the reason why we felt this is going to be a fundamental issue for the country's future in the next 20 or 30 years. Until our democratic institutions are stronger and our electoral process becomes more mature, and the system can withstand certain vicissitudes. And in consultation with all these people, this was done. And the government finally acted, and they brought about a bill, the 120th Constitution Amendment Bill, which lapsed unfortunately with the Supreme Court's, with the Parliament's dissolution. But when the Parliamentary Committee examined that, our colleagues from Lok Satta and I appeared before the Parliamentary Committee, and we made detailed submissions. They were available in the parliamentary records. Several hours of submission, 2 to 3, I think 3 hours of submissions are made. And there was a lot of interaction and debate. And the current government again took it up as the 121st Amendment. And this bill is a sensible one. And some of the suggestions made by the opposition in Parliament were accepted. For instance, if the President rejects the recommendation once, the second time the committee makes a recommendation, it's mandatory for the President. In the bill, they said the second time of the President's rejection, then only if a unanimous recommendation is made by the National Judicial Appointments Commission, will it be binding on the president? Quite rightly, the Congress party main opposition argued that you are making the bar much higher and therefore giving a single member the veto powers and appointments. That's not very wise. That's a correct position. The government agreed to that and amended it, and therefore, whatever is the provision in respect to the first recommendation will also apply to the second recommendation. That's a good provision. In fact, when we made our recommendations, Justice V.R. Krishnaiyer argued that even removal of judges must be by this commission, on the recommendation of this commission. But the two other juries, they felt that may not be called for at this stage, therefore, we did not include in the recommendations. Otherwise, V.R. Krishnaiyer went on record in his writing, that it must be also for removals. As we all know, in India, the parliament is empowered very much like the American parliament, American Congress, to remove the federal judges. But unfortunately, the powers of impeachment under Article 124 were never applied in the country, even in cases where there was incontrovertible evidence of misdeeds by judiciary. In the one case that the judge was forced to resign, it was not because of the parliament's action finally, but before the, I think the upper house already passed the articles of impeachment, but before the lower house could examine, the judge resigned. Otherwise, there is no case in India when a judge was removed by the parliament itself. Therefore, the impeachment provisions actually failed in India. There is a case to do that also. But at least in terms of appointments, this is necessary. This is long overdue. You cannot allow any organ in Indian constitution to act as supreme. The word supreme does not mean that they are supreme. That means in matters judicial, their word is final. But they are not the last word in a democracy. There is parliament, there is executive branch of government, the government of the day that is elected duly, and there is judiciary. All the three organs must respect each other. There must be a balance and there must be separation of powers. This was practiced in the United States and elsewhere. In the US, for instance, the Supreme Court, in an overreach, not of this kind, this is unthinkable in the United States, but in an overreach in interpretation of the law, they quashed many legislations made during FDR's time, the New Deal legislations in the wake of the Great Depression. Then, at that time, there was a big debate in the United States. The president, FDR, he said, if this continues, I will appoint judges of my choice because I'll have opportunity. You remember he was president for 13 years. Whenever there's a vacancy, I'll appoint people of my choice. This is simply wrong. And then the Supreme Court understood the gravity of the situation. They're going against the nation's will, and they changed their approach. You cannot have Supreme Court or the government of the day to completely rewrite the Constitution. When the Constitution said there shall be appointment in consultation, how can the judiciary take over the powers and say, we will decide who should be appointed? Our word is the last word, and that is the meaning of judicial independence. This is a complete judicial overreach. There is a self-serving approach, and this approach has failed, as recent disclosures have shown. And as many of us who have some understanding of judiciary in the country, we know, there are many judges whose integrity was suspect, including a Delaware, the Chief Justice of India. Therefore, let's not pretend that there's any organ which can be trusted beyond a point. Every organ must be under scrutiny. Every organ must be kept under check by other organs. Otherwise, the very Supreme Court which we trust today could be tomorrow a problem for the country. Its very credibility may be undermined. And therefore, 121st Amendment, as proposed and as passed by the Parliament, and that needs to be passed by the state legislatures, half of them, is actually a salutary effort to bring back some balance and to restore the credibility of the Supreme Court, the authority of the Supreme Court, so that the country will be well served. And people who are arguing that this is taking over powers from the Supreme Court is nonsensical. It's the Supreme Court that has taken away powers from the legislature and from the executive as granted under the Constitution. The Supreme Court actually had completely rewritten the Constitution without due authority because they were very weak and pusillanimous legislatures and governments for the past 10-15 years. They did not dare to counter this. But otherwise, there is an impressive consensus among political parties in the country. Everybody who has deep understanding of judiciary, including great jurists and former chief justices, they all know that there is judicial overreach and the current practice is wrong. In principle and in practice, it must be corrected. This corrective is now being put in place, and all of us should stand in concert with the Parliament on this issue. And if tomorrow's Supreme Court gives a judgment that this is unconstitutional, that is clearly overstepping their boundaries, and the Parliament must stand firm and not allow the judiciary to get away with this. Sharwani, the floor is yours.
Thank you so much, JP, for letting us know the importance of judicial reforms. Now, I'd like to ask Elizabeth, what is your opinion on this bill?
Just to give a bit of a different perspective from what Dr. JP put across. The original way in which we did appoint our judges was the executive appointing with the consultation of the judiciary. Somewhere along the way, when the judiciary felt that there was way too much encroachment or attempts to intimidate them, like happened after the emergency, when Indira Gandhi did supersede some of the judges to bring in people she thought should be in charge. That is where the judiciary, using some creative craftsmanship, converted this in consultation to concurrence and said that, hey, this is our domain and let's not have you interfere too much in this. Let's not have you try and get into this very valued feature of the judiciary, which is independence of the judiciary. Now, I don't want judges sitting there who are in any way scared of the executive in terms of tenure, etc. This was the reason why the collegium system came in, but it certainly left a lot to be desired. And over a period of time, it had raised several issues. We did have some terrible appointments. It had become extremely opaque and secretive. And this present bill certainly reflects the aspirations of people to actually broad base the entire appointment process to bring in far more transparency than we do see today. Having said that, I don't know if this bill is an entire solution at all. There is a lot more to be done. This bill talks about handing over the appointment, who appoints from A to B. But the more relevant things that should be brought into the debate are how the appointment process actually takes place. So, but how do you ensure, and in the document that Dr. JP was showing, Justice Venkatachalaya's and Justice Verma's document, they do mention at that point of time, as an alternative to at that point of time, the collegium system, the Judicial Appointments Commission system was recommended as a method of ensuring that everybody is there is a more participative process to the whole thing. But then Justice Venkatachalaya and Justice Verma did mention that it is desirable to have a wider consultation with participation of eminent citizens and jurists. We should have a wide search to identify people most eligible for the post. We must have elicit comments by publicly displaying the list. Now, these were attributes to the whole selection process that these eminent jurists did want to see brought in. And that was because it should not be treated as some kind of a largesse. Judicial post should not be treated as some kind of a largesse to be handed over, some method of nepotism or some discretionary arbitrary manner. Therefore, the how of the process, how do you ensure that you bring in certain criteria? How do you ensure this criteria is well known? How do you ensure you find people from the districts, from all aspects, from all the high courts? How do you ensure that you create a wide pool so that the best and the brightest actually enter the judiciary? How do you ensure that you test their merit against certain criteria which are laid out? Now, these are far more important aspects that I would say needs to be brought out in the national debate. Now, we are confining ourselves to moving from who else gets a pie in the appointment process. Is it just going to be A or is it going to be A plus B? I think that's an insufficient debate, and we really need to take it further into tools, criteria. And other jurisdictions around the world have done this debate, have tested out different models. And I think at this point of time, when this debate is out there, we shouldn't restrict ourselves to something small as this, but actually move on to bringing that bigger debate out into the...
Thank you so much, Elizabeth, for your opinion. Now, I'd like to ask JP how this would actually affect common man. So, I understood from your previous answer that in case of contentious issues, that's where the importance of this judicial reform bill will be apparent. Is that correct?
First, Sharwani, I entirely agree with Elizabeth. We have to make sure that the process is consultative, transparent. And the best of ultimately what we want is the best people, best suited in terms of integrity, judicial temperament, or understanding of the law, and constitutional principles. Otherwise, the whole exercise is futile. Doesn't matter who appoints them. The kind of people that we can trust to protect the constitutional idea. That's what really we need. And In that sense, the consultation is vital. But perhaps the lawmakers cannot really put an elaborate procedure in the Constitution itself or the law. It has to come through revolving procedures by rules and so on and so forth. And we'll have to insist on that. The second related problem is how do we ensure that there is actually a decent pool of consideration? Right now, in many cases, relatively mediocre people are chosen as judges in high courts. And not necessarily because they're competent, because the best lawyers are not willing to become judges in high court. Except in a rare case like Rohington Nariman recently, and one other case earlier, Chandrachud, I think, there is no judge of the Supreme Court appointed directly to the Constitution provides for that. It's always almost like a bureaucratic process which is appointed to High Court, and from High Court to the Supreme Court. And everything is almost roster bound and seniority bound like bureaucracy. There simply is no competence, no merit, no recognition that a 50-year-old could be an outstanding Chief Justice or a judge of the Supreme Court. And we are really making a mockery of the principle of competence. And that must be changed. That means in Indian Judicial Service, another recommendation made by the eminent jurists and recommendation made by Lok Sabha. That's also another bill right now pending relating to Indian Judicial Service like IAS and IPS. So the brightest young Indian lawyers or young Indian young people, they can actually compete to join this service, and they become within a few years' time the recruiting ground for the high courts and therefore eventually to Supreme Court. And also, we must start a practice of getting the finest lawyers in the country into the Supreme Court directly and encourage them to become high court judges or even chief justices directly. Until that happens, we have the best talent among the lawyers and mediocre talent among judges. There are judges in this country, I would not like to name them, some of them who adorn to the Supreme Court and some perhaps even adorning today, who never wrote a single judgment in the High Court in several years. This I got directly from some of the most eminent jurists of this country. They the people who knew everything inside out. They gave me specific details. This is not the kind of people. They may be personally honest. We require more than honesty. We require competence. We require a sense of urgency, a deep passion for justice, and the constitutional principles. And we are not getting that right now. The appointments made either earlier during the executive's regime or during the collegium time, they were pretty inadequate. Therefore, once you start making appointments of high quality, there are three things that will happen. One, as you said, whenever the judiciary is to adjudicate on fundamental questions where a nation could be actually driven apart, so to speak, we will be well served by a competent and credible judiciary. B, in terms of merely giving justice and enforcing rule of law, we require a high degree of competence. Today we have 30 million cases pending in this country. And the courts have become so status quoist that they don't want only judicial service. They don't want local courts. In fact, Lok Sabha again fought and got a 2009 law on local courts. It's just one small little step, but an important step ahead. So that millions of cases, simple cases, let us say for instance, short of serious offences like rape, etc., eve teasing, and day-to-day harassment of girls and women in our Indian streets, suppose they are addressed quickly within a few days, at the most a few weeks by summary procedure, and a penalty and some serious, even a month's imprisonment, and where required, your education record, it reflects your conduct, or your employment record reflects, therefore your future career will be affected. Suppose that fear is there, I'm absolutely certain that millions of young girls and women on the streets of our cities, they'll be safer. But for that, you require the local courts act to be implemented flexibly. Though the law is in place, though we could have appointed 5,000 judges like that, only 172 courts are appointed so far. It's a shame. It's a disgrace. The law allowed it. The law actually mandated it. And the single biggest obstacle is coming from the courts themselves, because they want status quo. They want to preserve their turf without really giving justice to the people. Though the high courts are fully under control of these courts, the local courts are kept under high court's control. Despite that, status quoism and preserving their turf is more important than actually giving justice and enforcing the rule of law. So once you have the quality of judges who are different, and they want really rule of law and constitutional principles and citizens' liberty above all, not their own notion of superiority or something. Whether judges or parliamentarians or bureaucrats, every organ of state, every individual in government in India, they don't think that they're there to serve the people. They think that they are the lords and masters of the universe. That's a very dangerous approach. A collector of a district or a member of parliament or a minister, they cannot take law into their hands. So the hope is that this is only a beginning. A lot more needs to be done in terms of ensuring justice is available to ordinary people from top to bottom, including improving the processes and speeding the whole issue, including getting the finest people into the judiciary and making it rewarding and making it prestigious like IAS and IPS today. And Lok Satta is working on all these fronts, and hopefully, step by step, all these things will come into place.
Thank you, JP. I think that answered Elizabeth's concerns, and hope this is a very good beginning and a lot of progress happens. JP, I have one more question for you. This question has actually two parts. Part A is Lok Satta and FDR worked hard over a decade on this bill, and if people and media notice our role in achieving this bill, would it be easier for Lok Satta to achieve more such reforms in the future, or would it really not matter? That is part A of the question. And part B of the question is, so far has any national media or state media recognized our role in this particular bill? If not, how will the common man know the role of political party Lok Satta in this bill?
It's a difficult choice. So far, we've been very conservative. Our position is that what needs to happen for the country should happen. That's the first priority. Our getting credit is not important, particularly if there is a clash between our getting credit and our getting the reform through. It's better that we seek the reform rather than credit, because oftentimes, public life is a very zealous one. The moment we claim credit too loudly, the political parties, the governments, the parliamentarians, they will all completely clam, like shut shop, and they will no longer negotiate with you, and they will no longer really follow your advice or be persuaded. Therefore, there is a danger that you get nothing done. For instance, many people who make a lot of noise on the streets, they no longer have the capacity to even talk to any political party or getting anything done. So we must really make up our minds what is it that we want. At the same time, for political gains, we need also for the people to know that this is what we have worked on assiduously. And that's where I really want all of you to pay attention and see what is the best way to do it with humility. While we underplay our role a little bit, we also get appropriate credit so that our ability to really reach out to the people that gets enhanced. But at the same time, we do not lose access and we do not lose the capacity to engineer further reform in the country. It's a very fine balance, but I think we should really try and get that formula right. And this may be a good case we should start with, and all of us together should go ahead together and see how do we do it in a manner that the country's interests are served, and our access and our ability to engineer further reform, it continues. And at the same time, we get the rightful recognition for what we have done and what we are doing, so that at least in terms of popular imagination, the importance of what we are doing is adequately reflected.
While the current bill focuses on the who appoints judges part, what about the how part? How does the current bill enhance the transparency of the appointment process, which was opaque and arbitrary in both collegium and pre-collegium era?
I entirely agree with you, Sharwani. That's what Elizabeth also said. The executive was appointing, particularly Mrs. Indira Gandhi's time, they were reckless. Mrs. Gandhi thought judiciary was its own handmaid. And while some of the people who were actually serving the government at the time were eminent people, I cannot seriously question Niren Dey's credentials as an eminent lawyer who was the Attorney General at the time, or the successive law ministers at the time. They were otherwise decent men, but they were cowed down by the Prime Minister, and they acted at her behest. And everybody knows the infamous, at least the people of my generation know, and younger people might have heard about it, the infamous case of Hegde, Shalat and Grover, the three eminent jurists who were superseded, and A.N. Ray was appointed in their place. And also, the later subsequently, when Mr. Justice H.R. Khanna, one of the eminent jurists who is no more with us, when he gave the judgment in the habeas corpus case to the Supreme Court during emergency, protecting the liberty of citizens, he was the only man who wrote a dissenting judgment, whereas the majority simply yielded to the Prime Minister's or the government's demands. And in a very shameless moment, or a shameful moment, the Supreme Court has failed to protect the liberties of citizens. So things were pretty bad. But now we come to the other extreme, where the Supreme Court is now trying to be Lord and Master, violating the constitutional principles and fundamental issues of democracy. We have a paradox where the Supreme Court now claims to be the authentic representative of people, and yet is completely unaccountable and is never elected. So we have to bring back some balance. And the happy thing is the political parties and leaders in government, whether earlier government or present government, my understanding, in fact I can even say with some authority, they recognize the need for a credible, independent Supreme Court, because I don't think any serious Indian who loves the country wants the Supreme Court to be undermined. They simply want to restore the balance. We must understand this clearly. Therefore, if anybody now exaggerates and says, look, this is the way of executive now trying to muscle in, that is completely far from truth. I can say with complete authority, and I'm prepared to go on record because I've had detailed discussions with senior leaders in Congress and BJP over the past 10 years on this subject. So they all understand the importance of preserving the integrity, the credibility, and the independence of the judiciary. But at the same time, they're deeply offended that the democratic process is undermined and the Supreme Court is now taking advantage of popular disenchantment with politics, is now overreaching itself and undermining the democratic balance. So we have to really have a very fine appreciation of what is happening in the country. And I have no doubt in my mind that in this particular case, the Parliament is right. And if some Supreme Court judges are now using the general anger against politics as an alibi to undermine the constitutional framework, I think we must very firmly but politely put them in. As he said, war is too important to be left to generals alone. Similarly, justice is too important to be left to judges alone. This is not the private property of judges. Justice is India's property. Judiciary is India's property. It's not the private property of the incumbent judge. That's a dangerous way of looking at it. And tomorrow, an official will claim that this is private property, he will put his sons in place. Day after tomorrow, the Prime Minister will claim this is private property, he'll put his wife or son in place. Already they are doing it by another way, but we cannot sanctify that. Therefore, this is a very fundamental issue for protecting the democracy. And there is a lot more to be done, and I'm sure that it will.
Does NJAC really eliminate the interference of legislature in judiciary?
I'm pretty confident, Sharwani. Let's understand, much more than the constitution, the culture of democracy, popular will, and the traditions established, they have far greater force. Take the Election Commission. The Election Commission does not even have the status of the Supreme Court. It is merely constitutionally appointed. Please remember, the appointment is entirely in the hands of the Prime Minister. And there were several appointments made which were pretty mediocre. I would not like to go into names. There are cases of Chief Election Commissioners, very questionable credentials appointed earlier. And yet, the Election Commission and the nation withstood these bad appointments also because already the tradition is established in the country of independence of the Election Commission and the conduct of elections. And the political parties, the people and the media have accepted. Even if a government of the day or somebody else was tempted to play foul, ultimately the public opinion itself in the country itself. Let us trust this. And the Election Commission sometimes, in every organization, every authority, every body wants to be self-serving. It is human nature. No body is exempt from that. The Election Commission also said, no, we must get greater constitutional authority. We must get our own budget. Our budget must not be voted by the Parliament. It must be already taken out of the consolidated fund of India. It happens in the case of Supreme Court. Now, all these demands are made from time to time. But and also removal of the Election Commission members must be by 2/3 majority of Parliament, like in certain cases. Judges, all these recommendations are made by the Election Commission time. But many of these are self-serving recommendations. Because an institution wants to be above the democratic process. We must see the outcome. As people of India, we don't care who is big, who is small. Nobody is big for us. We want to see that the right kind of outcomes. Elections must be conducted freely and fairly. Justice must be given speedily and efficiently and justly. Liberties of citizens should be protected. The Parliament should not transgress its jurisdiction and simply undermine the liberties of citizens. And the government of the day must act effectively, but with humility to serve the interests of the people. This is what we need. We don't want anybody to be a monarch in current day. And therefore, we must never accept at face value the arguments of the incumbent institution or the incumbents of the institution to protect their craft. You must only see the outcomes and fight for them. Already in the country, a culture of accepting the Supreme Courts and the High Court's legitimacy and supremacy in matters judicial is established. And already, in the case of Election Commission also, their autonomy and independence in conducting elections. And the political parties also accept it. If a government today does something foolish, the other parties are the ones who are going to fight with the name. The media will not accept it either. But that apart, we will have to ensure that the rules also frames in such a manner, and whatever is the tradition so far, that will actually protect the country. Therefore, let's not worry. Our constitution already is overwritten, where many of the constitutions are very big passages. We have a whole book which nobody in the right mind fully understands. Even eminent lawyers must refer to the constitution every day, every section, every day, and try to see what makes sense. But we have written so much about it. Writing too much in the constitution is not a wise thing. The practices we create, as well as the rules we provide for in the procedure that mentioned earlier, that's where the real thing lies. And more than anything else, the traditions were established. Here, I think India is safe. And our people already are wise, and our institutions are wise, and I'm sure they'll be safe. I have no doubt that independence of judiciary is now sacrosanct. No government, no political party will take on those days. That's the confidence now.
LSP has been doing phenomenal work but hasn't been able to capture the wider imagination of the Indian public. How would one communicate the importance and benefits of the judicial reform bill to the common person using simple language?
So only some things are, while the essence is simple, I don't think for ordinary people it is still simple enough. I don't think many Indian ordinary people actually know the basis. I suspect there are many Indians who actually are not aware that there is a constitution which operates, which is supreme. That there is something called the notion of rule of law. These are notions which are still very far from the imagination of the bulk of Indians. We are not a republic created by popular pressure. Unlike in the United States, where the local governments are powerful, states are seriously in their lives, and they fought against the king monarchy on the slogan of no taxation without representation. And they actually fought a war of independence. And then the states all sat together, negotiated, fought vigorously to protect their turf while creating the federal government. And slowly but steadily over decades and centuries, there's a revolution of the constitutional principles. The federal government acquired certain strength, at the same time it's kept under check. It's happened over a period of time. In India still, the bulk of the people, whoever is elected is a monarch. Whoever is an authority, even if is elected, is the monarch of the country. That is the notion. There is excessive dependence on those people. Therefore, in such a situation, let us not be over-optimistic about communicating these finer constitutional principles to the bulk of the people over time. We have to keep on expanding this area of understanding. And increasingly with greater education, greater democratic participation, and greater media role, by methods like this, for instance, YouTube or something else, more and more people are getting to know the finer points of the Constitution. But do not now exaggerate the ability of the bulk of the people of India to understand this. There are other issues like quality of education, healthcare, speedy justice, protection of our women, tax money being properly utilized. If they are adequately understood by the people across the nation, and if everybody while voting actually keeps that in mind, I think that's a great achievement. Let's not now think that the people understand the Constitution and the instruments of Constitution and then make a political judgment, informed judgment on basis. That is probably another 50 years ahead. Let's be frank. I'm quite content if they understand the other issues that affect their lives on a day-to-day basis and make a political judgment on that basis. Even that is not yet a reality in the country. Let's be practical.
This is from Kashyap from San Jose, California. He says that Lok Sabha played a key role in getting the Gram Nyayalaya Act passed in 2009. However, less than 200 of the 5,000 target courts have been set up so far. Why do you think there has been such slow progress and a relative lack of focus on this issue?
Great question, Seshadri. It happened because there was no serious political commitment. I don't say there is no political, I don't say there is political opposition, it's not true. But there is no deep political commitment. There was no passion. We pursued it vigorously and therefore they did it. But they did not feel it was an article of faith. Let's make sure that every ordinary person gets justice. Two, there is also lack of imagination. When the women's protection issue became so dominant in the public mind, the political parties and the government were smart. They should use this mechanism of local courts to really protect women and therefore got the popular solution. Three, the judiciary plays quite spot. We have made sure, after considerable experience, that the local courts were entirely under the control and supervision of the High Court, so that it's actually an integral part of independent justice. Are there many well-meaning but somewhat unwise people? They suggested these should be courts of elected people. There must be Nyaya Panchayats, the Gram Panchayat, the village Panchayat must have a say. We oppose that firmly because we understand India's systems, we understand the caste system, and therefore nobody in his right mind would go on justice system to be under the control of elected people. It's a very unwise thing. Even in the United States, where there are election of judges, by any standards, it's a very foolish and unwise thing. We must understand. In India, to now start doing that would be an extremely dangerous thing. So we've taken all precautions. Despite that, the judges in the country, they all come from the lawyers' part. Their basic loyalty is to their fellow lawyers. It is not to justice itself. And therefore, there is a perception, wrongly again, that once justice delivery is decentralized and local courts can deliver justice, then the lawyers who really live in big cities or towns, they will be at a disadvantage. And therefore, delivery of justice is not important, the lawyers' livelihoods are not important. Though, in the country we are producing more and more lawyers, and many lawyers are without briefs. Actually, if there is justice delivery, more and more young lawyers will get more work. The established lawyers in Hyderabad and cities, they may see that some of the work is going with some other people. But still, who are the judges after all? Who are they caring for? The lawyers in big cities. So it is this institutional bias and prejudice that is holding it back. And unfortunately, despite the constitutional and legal mandate that there shall be local courts, it is these high courts, this is Andhra Pradesh, I know for a fact, from United Andhra Pradesh, there is one high court for both the states. It's the high court that was somewhat lukewarm. It is the pattern throughout the country. And we have to break that. And one way of doing that is making it a popular issue and a women's rights issue, a women's protection issue. That's why you notice Dr. Satta is not talking about this as an important step in protecting women and in guaranteeing their safety and punishing the fellows who act funny with women on our streets. And I think we will achieve a measure of success if we do it well. And that's what we know about in the coming weeks.
The role of lawyers cannot be forgotten. So he's asking, what's the role of lawyers in the JSC bill, in the JSC bill?
First of all, I must be candid. Lawyers are important stakeholders and officers of court in the justice. But the courts are not for the lawyers. Now, somehow in India, the moment we have personal economic stakes in an institution, we think it is our property. Employees of government think that government is for them, not for the people. Politicians elected to office think that the legislature is for their own comforts and their own privileges. The judges think it is for them. The lawyers think that the courts exist for their livelihoods. Now, certainly, the law officers are important stakeholders. But the people are the ultimate stakeholders and they are the sovereigns of the country. Therefore, to the extent that the lawyers are stakeholders and they are also knowledgeable people in the matters of judiciary, they must have a role, but in an institutional manner. Therefore, in the consultative process, in any sensible procedure, the bar associations and the bar councils must be actively involved. Apart from the citizens groups and the human rights groups and the media and the general public research. That is what both Mr. Justice Seshadri and Justice Seshadri they argued for, and we incorporated that in the recommendations. And we will now work very hard to see that that becomes part of the process in actually bending the rules and the procedures. That's what we should all argue for, and we will start doing that.
Ravani, can I just add to that?
Sure.
Yeah, just answering Teja's question on the specifics of how the lawyers would be involved. I think one of the demands which is about making this process far more transparent and ensuring that I mean, today we know that so and so is appointed as a judge on the morning that the appointment comes through, or maybe a couple of days before the appointment comes through. And one of the attempts through this entire process is to ensure that wide consultation happens. Now, the bar members know about each other. The bar is like the most information you will get from is from within the bar. One of the things that we should be demanding is that lists of potential judges, of judges who are in the process of nomination, etc., these should be put out so that those who need to send in their objections or complaints, etc., this can be done. And that's a very important role that the bar plays. To be an active, to monitor these lists and ensure that we don't have elements where integrity is lacking coming onto the bench. And lawyers have played that role even where we have elements. For instance, in the Justice P.D. Dinakaran's case, it was a forum of lawyers who actually took this forth and pushed it to the level of to the process of impeachment and immediate resigning the court.
Is it about our role in persuading the UPA government, and will we play a role in the India government now in a similar manner?
Sure. Yes, that's the question.
Okay. Sirvani, as a movement under the political party, while in terms of electoral politics we will certainly complete. But once elections are over, we believe that all of us really fight for the same thing. Therefore, unless we have the ability to negotiate, to discuss, to debate, and to persuade and to build a consensus among the key players, and like it or not, we don't like their faces, doesn't matter. But it so happens that they are the constitutionally elected people to make a decision. Now, unless we really persuade them and find arguments, and unless we find ways of bringing a consensus in Parliament, nothing can happen in the country. Therefore, we have always chosen the path of keeping both the players, the government and the opposition, fully informed. The reason why many laws were enacted in India without a fuss. For instance, our candidate disclosure law, it came about through confrontation because we went to the Supreme Court and we fought a battle against the parliamentarians. But even then there was consultation, finally there was a consensus. But that apart, other laws, we take the political funding reform entirely by consensus among the political players and by unanimous consent. Right information law, again entirely by consensus and unanimity. Local courts, again entirely by consensus and unanimity. The 91st Amendment to the Constitution, limiting the size of the Constitution sets up on 97th Amendment I mentioned about the cooperatives. The 121st Amendment now. All these happened because we brought these players together in very difficult. And therefore, we continue to do that, irrespective of who is in power, whoever is the Prime Minister or whoever is in opposition, doesn't matter to us. But we do it in a fair manner and it will be open. It will not be conspiratorial. It will not be you scratch my back, I scratch yours. It will be dealing with all parties equally and being very transparent. If we talk to opposition, keep the ruling party. Talk to the ruling party, keep the opposition. And there is nothing secret in what we do. Do it openly and peacefully and honorably. And that's the reason why they all give some weightage to what we say. And it's possible to build a consensus at least some other things to do. And we'll continue to do that, and I hope we'll be able to do it as effectively today as we could do it.
There is no serious effort by parliamentarians to set up all India judicial service to meet the burden of human cases. What can Lok Sabha do to bring progress in this aspect?
Okay, Sharwani, if you notice, the recommendation this committee gave at our request was also encompassing All India Judicial Service, if you see, National Judicial Commission and All India Judicial Service. And on the basis of this, the Government of India did draft a bill which is now under consideration. It's not under the Parliament actually. But unfortunately, Supreme Court itself is opposed. Judges, at least legal judges, Supreme Court. Because again, there is an institutional bias. The challenge of India is how do you get people like Elizabeth into judiciary? Today, the only serious channel of recruitment to judiciary, there are two channels. One is the district judges selected after some years, after several years, oftentimes before their retirement. By virtue of seniority in most of the cases, they end up being high court. The other straight is when the lawyers, after years and years of practice, and because they are familiar with the judges, some of them are going to be competent and they are not case, or they have political skill or whatever. And if they are willing, this is important, they become judges of the court. Normally, At that age and seniority, once they really become very successful, there's an enormous economic salary. Good lawyers make millions of rupees in a month. And the judge, no matter how good, cannot make more than a lakh or 2 lakh rupees. I don't know what they manage, but I would be surprised if Supreme Court judges gets more than 2 lakh rupees a month. That's about maximum. So where is the comparison? And good Supreme Court lawyers make crores of rupees. There's a great sacrifice involved. They're not willing to do this. So unless you catch them down, unless the brightest Indians really come into this as a passion to a nationwide competition, and that means you must begin some other attraction. Why do the best Indians with good IIT, IIM, medical other classes qualifications make lots of money outside? Why do they come into IAS and all civil services? Because there's a glamour attached. There's an All-India country. All-India service is a certain aura. If you create some such aura, this also we can attract the finest people very young. They become distributors almost immediately in a year or two. And then once they are distributors for a few years, they can automatically become high court and judicial. That's very important. That's the logic behind it. Precisely why many lawyers in high courts are not particularly happy about that. And many judges of high courts are not particularly happy. And the Constitution actually provided for this. And several law commissions repeatedly recommended this. Supreme Court actually at least on 2 occasions endorsed it, formally as a court. And the Judges Conference, Supreme Court Judges and High Court Judges Conference, formally endorsed it. And yet, informally or formally, the sitting judges keep opposing that. And generally believing that the judges have the final word in matters of recruitment of judges. You are keeping quiet. This is nonsense. We need an all-India judicial service because I can tell you with complete authority, and Elizabeth can also the quality of judges today is pretty abysmal across the board. There are a few outstanding judges, but many judges are mediocre. There are many who can't write one paragraph properly. There are many who cannot understand the logic of the Constitution and the basic principles of the Constitution. There are many who cannot adequately understand the case law. There are many Supreme Court judges who give very haphazard judgments without any raising this. This is all chaotic. This is not right. We must change it in the interest of the judiciary and the country, and therefore the finest Indians must get into it. Without any kind of pull, without any political pressures, merely because they are the most talented, the most good. We have such bright young people. We must start from young. And right now there is a consensus in the country to have the judicial service. The next thing that we are going to pursue is not only it's one stage. The next thing we are going to pursue is the judicial service. Whether we require the resolution of the Rajya Sabha and the Union Constitution to create 1 year service. The upper house, which is the council of state, has to do first. And then a law must be made under the Constitution to create a framework for the all-India services. And if any constitutional text itself has to be changed, in this case I believe there is some change that is warranted, because the all-India service under the Constitution now cannot be for a rank other than district. At least on day one you want them to be district. But also is not right. It's good to have 4 previous experience before they should be. It's like, an IAS also becomes collector on day one. Definitely not. Obviously guaranteed to be collected in 3 years, but has experience before it becomes collector of people of rights. Unfortunately, constitutional wording does not allow it. So we must find a mechanism, create a mechanism now, or we must change the constitution first. It's not a substantial change. Now there's a second way of constitution. So all these processes are now underway. The issue is being examined by the law minister, the prime minister. I'm sure we can build a consensus in this.
JP Garu,
Tamil.
what are the systems we have in US, UK, in other countries like China?
In appointment of judges,
Yes.
one thing I can say is no country in the world do judges appoint themselves. In the US, in Britain, and other countries, in the US, of course, you all know, the federal judges are appointed by the president, but they are nominated by the president. But the Senate is asked to advise and consent as the Constitution. At least the Senate must ratify all the cabinet appointments, all the senior appointments in the executive branch of government, and all the judicial appointments, and all the federal. The US has the most democratic, most participative, most transparent processes, almost to the point of making judicial independent. In the process, judges of real quality today, they are so politicized that real jurists of real quality cannot be found with judges in the United States because the moment they have only on abortion, on women's rights, or on something else, immediately they become politically contentious no matter how strongly argued those cases are, how impeccable their logic is immaterial. Therefore, colorless, tasteless, and useless judges are appointed in the United States increasingly. They must be non-controversial, they must never have any use, they must never have expressed anything, they must never have in some other court really given their views with great clarity, and therefore the people who never had any such views keep themselves used themselves. They are the most likely people to be appointed. That's not a wise thing either. In Britain, you have a system of the executive appointing, but they do it after wide consultation in a fair and objective manner, and it's working very well. So is the case in all democratic countries. China, of course, is an autocratic country. It's basically a party affair. Therefore, Chinese example does not apply to us at this point of time. China hardly qualifies as a transparent democracy. The day it qualifies, certainly we'll examine that. But right now, China doesn't bother about these things. They appoint people whom they like. But even there, if you notice, whether it's appointment of their national leaders or some others, there is a principle of meritocracy. Subject to party control and party loyalty to the party, they do follow a principle of meritocracy. That's why the system is survived. That's why the system is actually delivering. India is the only country where it's almost like a mullah Raj, where the incumbents decide their successors. It is patently unconstitutional and self-serving. I'm using strong words because the arguments advanced by judiciary are unacceptable. And it's not serving us well. We are not getting men and women of quality into judiciary. We have to change it, but at the same time, we cannot allow the government of the day to dictate, as Elizabeth said. We must ensure that the country is well served and they function as an independent institution only for the people of the country and for the Constitution of India.
Yes, in the newer judicial appointment method, if a judge commits a malpractice, how should he be prosecuted? Yes.
There are two classes of judges. One class is subordinate judges below a high court judge, the district judges and the subordinate court judges. All these people under Article 235, they come under the High Court's jurisdiction fully. The High Court has all the powers from appointment to removal. Appointment is by the governor, but that's notional. Really speaking, finally, the High Court decides. But more important, the removal is entirely in the hands of High Courts. Several High Courts, like Maharashtra High Court removed 150 judges in the lower courts on grounds of either incompetence or corruption or both. Similarly, Rajasthan High Court, Bengal High Court, they all did it on a smaller scale. It's possible if the High Court has the will. It's not a political issue, it's not a legal issue, it's entirely High Court's jurisdiction. Unfortunately, many other High Courts are more than happy to condone corruption and incompetence in their subordinate judges. So the Supreme Court gently must nudge the High Courts because unfortunately the Supreme Court doesn't have powers to tell the High Courts what to do. But High Courts in some respects have greater powers in India than the Supreme Court of India. High Courts directly can control all the subordinate courts. Supreme Court does not control them. So the High Courts are supreme. As far as the High Court and Supreme Court judges are concerned, the current practice is simply inadequate. There are far too many corrupt and incompetent judges in India, and the constitutional mechanism to bring them to account has failed. And in any case, apart from removal, there is hardly any other mechanism available in the country. Therefore, now there is a two-step approach required. The first step is there must be a permanent mechanism to investigate complaints into judges' conduct. We don't have it right now. Therefore, already judicial standards and accountability bill is now, it was before Parliament. Again, it I think lapsed because of the dissolution of Parliament. Again, it will be reintroduced now, I hope. I'm sure it will be reintroduced. And that must be enacted. And it's a fairly well-conceived judicial standards and accountability bill, establishing certain standards of conduct, which the judges themselves, and Justice J.S. Verma was the Chief Justice of India. The Judges Conference actually recommended, made a statement on the judicial conduct and the code of conduct. Now, that code of conduct is more or less sought to be sanctified. In addition, a mechanism is now sought to be evolved on a permanent basis to ensure that there is an authority available with the judicial members, former judges, Supreme Court, etc., to be able to examine the conduct of judges. Now, there are two kinds of conduct. One will be conduct where it does not warrant dismissal even if it was proved. Not corruption, not serious abuse of office, but a minor misconduct. In which case, advising, counseling, a bit of censure, or transfer of judges would be adequate in case of high courts. But the other cases where it warrants dismissal of the judge or removal of the judge. In which case, this body is expected to make a recommendation to both houses of parliament, and the parliament will then act on that. And generally, expectation is once this kind of a body, after due investigation and inquiry in a transparent process, has come to a particular determination, then the parliament will act to remove them if necessary. I think it's a good enough system. The third step, if the parliament is inclined, would be to give the powers of removal itself to an independent judicial commission like this after due inquiry and make their recommendation mandate. That, as I said, Justice Krishnaya did recommend, but perhaps that may not be even necessary. If actually an independent authority makes a recommendation, not a government-appointed body, not a political body, not parliament, but an authority like this after due inquiry makes a recommendation. If the parliament makes it a practice to go by that recommendation unfailingly, I think that would be good enough. And if that does not work, then let us see if we require to further amend the constitution to give powers to such a body to remove altogether. But right now, I think judicial standards accountability bill, if it's properly implemented after enactment, along with the 124th Amendment, now we are trying to bring about 121st Amendment, amending Article 124, and along with All India Judicial Service, along with local courts, I think together we'll have a framework to make judiciary far more effective and far more both independent and accountable.
With whatever has happened so far, like the passage of this bill, can you give your comments on this?
Is that to me, Shravani?
Yes, yes. Yes, sir.
Yeah. Swami, I think what you're asking me is for some comments on this whole process of judicial reform which is happening. I think it's a fantastic time we are seeing in India, because never before have we seen the kind of conversations we've had around the judiciary as we are seeing in the last 2-3 years. And I think it's a very healthy sign that people, the media, the people are talking about it. The judiciary also has realized that public support is something that keeps the judiciary, the majesty of the judiciary. It isn't about the red light cars, etc. But it is people's faith in the system that keeps the majesty of the system and keeps it going. The judiciary doesn't have the kind of funds or the policing machinery to implement its orders. It's all about public confidence, and therefore, if this conversation results in systems that increase public confidence in this dispute resolution mechanism, and the judiciary is not just a dispute resolution mechanism, it is also one of those key limbs of governance which has to uphold the constitution. And the Indian judiciary has gone, well, some people call it judicial overreach, and the others call it legislative underreach and executive underreach. And the Indian judiciary has done yeoman's service in several areas where governments have failed, where nudging the legislature to take action where it hasn't, and where executives have failed. So the executive has failed, and therefore it is important that we retain public confidence in the judiciary. And if this conversation can move to certain kinds of reforms that ensure that we don't, to a large extent, we have good people on the higher judiciary. If we can ensure that those few cases which has brought a lot of bad blood and bad name to the judiciary, if those kind of cases can be minimized and eliminated, if at all, then I think it's a fantastic conversation which is happening around in the country. And in terms of judicial reforms, yes, we need speed, we need efficiency. And you were asking a question earlier, how do we get this point across to the ordinary man? How do we get him concerned? Shravani, believe me, every house is concerned with the legal system today. There is either a custody issue or a divorce issue or a property issue or a water issue or some issue wherein they are dealing with either governments or dispute resolution in a civic sense. Every house is concerned with the delays and the high costs and the inefficiencies and uncertainties of the judicial system. And therefore, if this message can be taken, this is something that can be taken to the people, which would touch their hearts and minds, and it's a reform whose time has come, and I'm extremely happy to be part of the Lok Satta movement, which is is doing this, which is probably one of the few parties that is showing the courage to take on this reform process.
Could you give
Okay.
concluding remarks?
We had a very lengthy discussion on an otherwise dry topic. First of all, I must congratulate Rwani and Sambireddy and all the most of the leaders and volunteers, because it is this kind of public participation and serious debate on institutions and issues that's going to shape our democracy. Elections are important, but they're not the only way to shape it. We are still somewhat immature as a democracy. We have to go a long way. And unless we start recognizing the importance of every institution and the details, unless we are fearless in criticism when it's warranted, but with respect, with dignity, without undermining the institutions and their credibility, we have a right and responsibility to criticize them when they go wrong and to support. And in a democracy, no individual, however exalted he or he is, no institution must really think that they're above reproach or above public criticism or above reform. In India, there is a general approach in all branches of government, in all groups of public servants. You go to a group of civil servants, you tell them, look, there's a reform required in the country. When it pertains to reform in parliament or political parties or elections or judiciary, they'll all say, what a fantastic approach. It's absolutely right, we require that. The moment you talk about civil services reform, all civil servants find 1,000 reasons why nothing should happen by way of change in civil service. Even as they privately complain about what is wrong, they don't want change. Go to politicians, they say it's wonderful that we should think of reforms of civil services, of judiciary, etc., but not politics. Go to judges, they say everything else in the country should reform, but as far as they are concerned, status quo is the best. This is a normal human tendency. We must not allow them to get away with that. Any branch of government, any individual functionary. A true democrat is one who will question everybody, will be skeptical, and yet understands the measure of balance required in institutional structure. Don't be reckless, don't be iconoclastic, but be skeptical and hold them to account. And that is the spirit in which we are approaching this. We should approach every institution, every organ. And this actually to strengthen our democracy, but otherwise, today there is so much of cynicism in India. There is so much of mistrust. The general public now thinks that everybody in India in a position of authority is fundamentally bad. Earlier, we used to think that the politicians could do no wrong because the first generation politicians were freedom fighters. They sacrificed a great deal. We trusted them. As that trust evaporated, we thought that the bureaucrats could do no wrong. In assemblies and parliaments, whenever there was a debate about some institution, some organization that were collapsing, the general tenor is, all right, we'll appoint an IAS officer to be in charge of this organization. There was a time when in Bihar, every university had an IAS officer, the vice chancellor, IPS officer, the vice chancellor. That was the blind faith in the All India services. But as that trust evaporated, in the past 20 years or so, we started saying, all right, we'll go to Supreme Court or High Court. But even that trust has now in some measure evaporated or is evaporating. So what else do? Do we go to the army? We want to bring in the chief of army staff or some military commander to take care of the country as Pakistan? This is a very dangerous road. Unless we restore primacy of these institutions, credibility of these institutions, bring the best and the brightest into the institutions, and also hold them to account so that our trust is not abused and we will not lose that faith and trust. The country itself is in danger, democracy in danger. You don't have to go far, just look at Pakistan. How people have no faith in any institutions, and once the elected government is now under threat, by all accounts, Nawaz Sharif government was elected fairly. Many international observers and bodies were there to monitor. I'm sure there was some mischief, like in India there is mischief in elections. But on the whole, elections were free and fair. There was a peaceful transfer of power. And yet, the street is dictating the future of Pakistan. 40,000 people now in the streets of Rawalpindi are now dictating the future of Pakistan. That's the last thing we need in this country, in India. We have to make our institutions work, and that means we have to be fearless. And this debate that you are initiating, this debate that we are all participating in, this fearless discussion in dealing with Supreme Court judges and High Court judges, and in dealing with the future of judiciary, but in a respectful way, at the same time fearful way, is the right way forward. I'll conclude with one anecdote. One day, I was chairing a session. Mr. L.K. Advani Mr. Justice J.S. Verma, late Justice J.S. Verma, Suresh Prabhu, these three were the panelists. Sheila Dikshit, then Delhi Chief Minister, was to be there, but she could not participate for some reason. I had to invite Justice J.S. Verma before inviting L.K. Advani to speak. I said, it is our misfortune in India that the Chief Justice of India, that position does not guarantee the integrity. And therefore, when you refer to them, you also sometimes have to say that they are honest. You can no longer take honesty even in a Chief Justice for granted. It is my privilege to now invite a truly honest Chief Justice, Justice J.S. Verma. Who are the people sitting in front of me? The then Chief Justice of India, incumbent Chief Justice, was sitting in front of me in the first row. And the number 2 judge next to Chief Justice is sitting in the front. L.K. Advani put his arm on my knee and said, Jayaprakash ji, aapne kamal kiya. I said, Lalji, what? He said, you are so outspoken. I said, if you and I are not outspoken about these matters, to restore balance to our institutions, we will do. We have an obligation to the country. We must be unafraid, but we must be fair and very balanced and very wise. We must not be reckless. We must not undermine institutions, but we must be fearless in criticizing what is wrong. The notion that anybody is above law, above constitution, is a dangerous notion. And I'm happy that the democracy is maturing. Our institutions are maturing. They are also accepting this criticism. Earlier, there was a time when the Parliament or the Prime Minister or the Supreme Court did not brook any kind of criticism, even the mildest criticism. Today, they are accepting with humility, which is a good sign. It's actually a sign of maturity. Do not create holy cows. Let us hold them to account, but let's also preserve their independence and their credibility in the long term. That's exactly what we're doing. I think we should be happy and proud about that. And let's not lose faith in our democratic institutions or the Constitution. Ultimately, with all our flaws, the country is working out reasonably well, and we will make them work and make them better. I think we've had enough of a debate. I really must go, and I'm sure all of you also must be really busy. Wish you all good luck, and good night for those in India, and good morning for those in the United States, or good day, and for those in Europe and elsewhere, have a good day. Good night.
Thank you, JP. The democracy is maturing on that positive note. Thanks for the knowledge transfer about the judiciary reform bill. Good night.